to. Ione Wells, BBC News.
Let's get more reaction. Joining me now is Satvinder Juss, a barrister and Professor of Law at King's College London. Thank you so much for being here on the programme. What, in your view, were the key parts of today's judgment from the Supreme Court?
Well, the Prime Minister has announced that it remains committed to sending people to a safe third country. The short answer to that is that Rwanda is not a safe third country. And there are three reasons for this, why even a new treaty is not going to work. Firstly, Rwanda has a history of acting in contravention of the principle of non-refoulement. And it continued to do this during the negotiations for the Rwanda policy, and indeed after the execution of the Rwanda policy. And so that's a simple reason for why you cannot trust the Rwandan authorities. The other thing to note here is this, that Rwanda has a history of considerable political turmoil. One remembers the genocide where 500,000 Tutsis were killed by the Hutus, and that political violence continues, so much so that the judgment points out that there has been political killings and assassinations by the Rwandan authorities to such an extent that the British police has had to warn Rwandans in this country to be careful. Indeed, the government there has even shot at refugees in Rwanda, killing at least 12 people. It doesn't stop there, because one finds that it has next to no understanding really of refugee law, because although it has an open door policy in relation to other Africans from Burundi and from the Congo, it has little to no experience of refugees being sent over from Europe. Indeed, up to 2022, it had only processed 152 applications. And moreover, it's fundamental to any refugee system that ultimately there has to be an effective right of appeal. Now, a right of appeal has existed in the law there since 2018. Not a single appeal has ever been lodged.
Yes.
So the system simply is not working. And might I just add this also, that the reliability of the system is also open to question in this way. The majority of the refugees that come to this country come from areas of profound conflict, Syria, Afghanistan, Yemen, and so on. Rwanda has 100% rejection rate for those countries. In this country, we allow 98% of Syrians refugee asylum status, 74% of Afghans, and 40% of people from Kuwait. So plainly, there simply is no sense of appeal.
You list, and it is a very long list you have just taken us through, of all the reasons why the Supreme Court have come to this view, and it was unanimous. We've heard, and you touched upon it right at the beginning, Rishi Sunak saying that they're going to try to negotiate a new treaty. Do you think there is any likelihood at all of a new treaty actually addressing all of those key planks, those key problems you've just outlined?
Absolutely not. I mean, might I just add that the judgment, in fact, is a masterclass in the way in which rules are formed, starting with general international law, treaty obligations, domestic law, rules and delegate legislation, and finally MOUs and agreements signed. And it makes it quite clear that even if we were to alter our domestic arrangements and come out of the European Convention of Human Rights, we still remain bound by the Refugee Convention, by the Convention on Torture 1984, by the International Covenant on Civil and Political Rights. So the judgment is very, very carefully drafted and actually a resounding affirmation of the extent to which the rule of law continues to be maintained by our apex court. And that, again, comes as no surprise, because the leading decisions across the world in refugee law look to the British Supreme Court in giving the finest decisions, really, when it comes to questions of sanctuary and asylum status. So that's not going to cut it. And the other reason...
Before you go on to another reason, let me just tell viewers that Suella Braverman, the former Home Secretary, sacked only 48 hours ago, has posted a response to what we've seen from the Supreme Court. Let me just go through the key bits she has posted. She has said the Supreme Court judgment is no surprise. It was predicted by a number of people close to the process. Given the current state of the law, there is no reason to criticise the judges. Instead, the government must introduce emergency legislation. The bill must block off ECHR, HRA and other routes of legal challenge. This will give Parliament a clear choice: control illegal migration or explain to the British people why they should accept ever greater numbers of illegal arrivals settling here. Professor, in terms of the approach the former Home Secretary has just laid out, the likelihood of that being effective?
Well, none whatsoever, because what the decision makes clear is this. This is not a case of tinkering with an existing agreement. It's not a case whereby you can rush back to the Rwandans and say, well, look, we need to actually perfect the original agreement. Let's put in place a new one. There are systemic, fundamental, structural problems with the way in which the Rwandans do asylum law. There is no understanding of non-refoulement. They proceed on the basis that a person who comes must come free of forged documents. Most refugees don't come in that manner. They proceed on the basis that you must apply for asylum immediately upon arrival. They don't come on that basis. But another thing that has not been mentioned at all, which the judgment goes into, is there had been a previous agreement between Rwanda and the state of Israel, whereby Israel dealt with its Eritrean and Ethiopian refugees by sending them over. Again, very, very similar arrangement with financial inducements and so on. And it made it quite clear that there were fundamental human rights obligations on the Rwandan authorities. And yet the Rwandan authorities did not observe those human rights obligations.
Yes.
No right to residence was given, and they were put under risk of refoulement.
Professor, I've got to leave it there, but thank you very much for your time. Let me just